High Court rules government consultations on compensating those affected by the proposed high-speed rail scheme are unlawful.
This is Sky News with Anna Jones.
Hello, good morning. The High Court has ruled that government consultations on compensating those affected by the proposed HS2 high-speed rail scheme were so unfair as to be unlawful. But the government has hailed the court's decision on the cases as a landmark victory and said the loss on the compensation case would not affect the HS2 construction timetable in any way.
This has been a convincing victory for the government. The judge has given us the green light to go ahead with High Speed 2, subject to the necessary parliamentary approvals. Of course, we understand and accept the judgment that the judge has made with regard to the process for consulting on compensation. We will look at that closely. We will not appeal against it. We will rerun the compensation consultations.
Let's cross live to Enda Brady, who's at the High Court in London. So, Enda, 9 challenges thrown out, and yet this issue of government consultations on compensation ruled unlawful. So how much of a setback is that to the government's plans?
Well, the government says absolutely no setback whatsoever. I've just spoken to the Rail Minister, Simon Burns, and he says that this will not delay the project by so much as 1 minute, full steam ahead. So it's very interesting. We'll get the reaction from the campaign groups in a moment. There were a total of 10 challenges brought by them. The judge has dismissed 9 of them. 1 of them upheld, and it was the key issue of compensation. So we can take a look now at the proposed route for the high-speed rail link. This is it. In phase 1, the line would start at Euston Station in central London. It would head up northwest, going past Buckingham, Brackley, Leamington, Spa and Coventry before splitting and finishing in Lichfield and Birmingham. Now, in the second phase, the line to Lichfield would be extended up to Manchester, going past Stoke-on-Trent and Crewe on the way. But a line would also have to be built up to Leeds, with Nottingham and Sheffield en route. Phase 1 is what was being contested today. Let's get some reaction from some of the campaign group leaders. Martin Tett is leader of Buckinghamshire County Council. Martin, your reaction?
Well, first of all, I think there's some really good news. The decision of the judge basically on compensation is fundamental. There's something like 300,000 people whose lives and businesses are blighted all the way up the line between here and the north. And now they're actually going to have to rerun the compensation consultation because they fundamentally ignored the whole weight of response from that. Tens of thousands of people wanted a fair compensation scheme, and the government went for a scheme that was supported by only 21 people. So that was absolutely bizarre, and the government has been found flawed on that. The second area of challenge was actually about the fairness of consultation on the principle of the route, particularly north of Birmingham, where, quite frankly, nobody got a chance to participate in that. Now, the rather bizarre judgment that's been handed down is that the government actually has made no decision on HS2 whatsoever. Not only north of Birmingham, but they haven't even made a decision between London and Birmingham. So those of us who've been living with this for the last 2.5 years, announcements in the House of Commons, decision papers, command papers, route details, etc. I think we've all been living in some parallel universe because the government has argued they have nothing more than a high-level philosophy for high-speed rail, and therefore they haven't needed to consult on the principle of the route so far.
But the government says this will not set back the project so much as 1 minute. That is what the Rail Minister has just said.
Oh, and that's absolutely right. And they're going to press ahead, I understand that. But that's the third area of challenge that's really strange, because we've said the hybrid bill that's proposed is incompatible with a lot of EU directives, and we've been told we have to challenge at the end of the process. They haven't said we can't challenge or we're wrong, just we're challenging too early. So what you're going to have is something like £800 million worth of taxpayers' money spent before the challenge takes place that could find this whole process unlawful.
Will you appeal? What happens now?
Almost certainly we're going to appeal this. It's such a bizarre decision that it just doesn't make sense to the ordinary person.
What's the strength of feeling like in the community? How much confidence will campaigners take from that 1 victory out of the 10 today?
I think there's real anger. I mean, people feel the government has been inherently contradictory in what it's done. I mean, it's argued that they're going to take people's property, they're actually writing to people, they're publishing details of routes, and yet they're now saying we've got nothing more than a high-level philosophy about high-speed rail. And they can do things up in the north around Tatton that they can't do down south. So I think there's real anger here and people want to fight on.
Is this your game plan from here now? Appeal, delay, and hopefully the next government won't be as interested in high-speed rail projects as this one was?
Well, what we want to do is try and convince the government that this is actually a fundamentally flawed project. I mean, the business case for this is absolutely fallen apart. It's really hard to find anyone who fundamentally supports this on proper value for money grounds. This has become a prestige project, and I understand why governments cling to those sort of projects, but there are really good cases for investment in infrastructure now that are going to bring jobs and growth when we need it, rather than something that's pie in the sky for 2034.
So what's the next step for campaigners? Where do you go from here?
Well, what we're going to do, obviously, is look at the opportunity to appeal. We're almost certainly going to be appealing at least two of the main areas of judgment today. But we're also going to carry on representing the best interests of our residents in terms of trying to get the best mitigation should this particular project go ahead.
Will it be a case that appeals can go on in the background while some of the groundwork starts in some of your communities?
Oh, absolutely. And I think that's only, what's going to happen. There's clearly going to be a decision by the government, although they claim there hasn't been a decision, of course, to proceed with this. They're going to press ahead. And at the same time, we will be working with them on mitigation. And at the same time, we're going to be appealing the decision.